5 seconds to go. Start. First, we deal with the objection of the respondents regarding the bar in section 301 of the CRPC, on the basis of which it has been argued that it is not open to the appellant, who is the spouse of the deceased, to pursue these proceedings. Stop. Para. The respondents have relied upon the decisions in Shiv Kumar versus Hukam Chand to further their contention. Stop. However, both these cases deal with this court having declined private counsel to conduct a prosecution instead of a public prosecutor in a sessions trial by relying upon the specific bar in section 225 CRPC. Stop. Accordingly, these cases can be clearly distinguished from the facts of the present case. Stop. In the present case, even the application under section 311 in the sessions trial was moved by the state, and there is no question of the appellant wanting to replace the public prosecutor in the trial. Stop. Para. On the other hand, the appellant was alleged to have been gang raped by the assailants who were arraigned as accused at the sessions trial. Stop. PW18 was a subdivisional judicial magistrate before whom the test identification parade was held. Stop. PW18 had recorded the proceedings in the prescribed format, and certain documents were marked as exhibit. Stop. The grievance of the appellant was that during the course of the examination in chief, an innocent version was spoken to by PW18 as an authorized officer who conducted the TIP. Stop. However, the prosecution failed to confront him with the aforementioned Exhibit 8 or to controvert the incorrect statement in order to remove any source of ambiguity which would otherwise prejudice the case of the prosecution. Stop. The appellant approached the special public prosecutor to set right the error of PW18 in his evidence and to confront him inter alia with a document marked as Exhibit 8. Stop. The public prosecutor not having taken any steps, the appellant moved the trial judge with an application for recalling PW18. Stop. The trial judge rejected the application on the ground of maintainability. Stop. Holding that such an application could not have been filed at the instance of the victim. Stop. The High Court, placing reliance on the provisions of section 301 CRPC, observed that the informant had a limited role to play and it was not open to her to file an application for recalling witnesses. Stop. Para. In this backdrop, this court examined the provisions of section 301. Stop. Section 301 is restricted below, para. The public prosecutor or assistant public prosecutor in charge of a case may appear and plead without any written authority before any court in which that case is under inquiry, trial or appeal. Stop. Para. If in any such case any private person instructs a pleader to prosecute any person in any court, the public prosecutor or assistant public prosecutor in charge of the case shall conduct the prosecution, and the pleader so instructed shall act therein under the directions of the public prosecutor or assistant public prosecutor, and may, with the permission of the court, submit written arguments after the evidence is closed in the case. Stop.